Good morning, everybody. Thank you for joining us in our webinar today, which will explore the topic of mandatory COVID-19 vaccinations in the workplace. My name is Panellist, and I'm a content coordinator at LexisNexis. I'm pleased to be facilitating today's session, which is powered by our online research solution called Library. So internationally, the COVID-19 pandemic has seen several employers move towards making COVID-19 vaccines mandatory for all employers. So now we've seen South Africa also starting to follow suit. Now there's been a lot of tussle about this issue and a little bit of back and forth, but today we'll be examining the applicable legislation provisions underpinning this important issue. So I'm very excited to announce our two esteemed guests, our labor law experts here to share the insights and their guidance. So Dr. Hilda Grobler and Naidoo will each be presenting today, and I'll be handing over to Dr. Hilda first to take us through an overview of vaccination, legislative provisions in South Africa, and employment labor dispute implications in South Africa. Now, Michelle will take over straight after Dr. Hilda, and she will cover the approach of South Africa, states, and educational institutions towards mandatory vaccinations, as well as present a comparative global perspective towards mandatory vaccinations. Now, to our attendees, if you have any questions that spring up during the session, please remember to use the Q&A tab. I think it still appears at the bottom of the screen, and then we'll get to those at a later stage. Please pop in the questions immediately as and when they come to mind. And then what we'll do is, as we get to the latter part of the conversation, we will tackle those Q&As. So without further ado, let's get straight into the main course. I will hand over to Dr. Hilda Grobler and Naidoo.
Thank you. Good morning, everyone. If I could have my first slide up, please. Thank you. And if you could move to the next. Thank you. As you can see from this slide, vaccination remains the primary way to reduce death and severe illness caused by COVID-19. These wise words come from Professor Shabir Madhi. Professor Salim Karim said that vaccination provides the maximum protection against the virus. The emphasis is on maximum. And Professor Jonathan van Tam, one of England's deputy chief medical officers, recently warned that people should not assume the pandemic was over or let their guard down. Can we please move to the next slide? All physical interactions are subject to the regulations issued in terms of the Disaster Management Act. It is a fact that at this point, vaccination is still a choice. It is not yet mandatory. However, on 11 June 2021, an update was published in the Government Gazette of the Consolidated Directions on occupational health and safety measures in certain workplaces. In some quarters, these directions have been interpreted to mean that all employers are now entitled by law to simply subject all employees and independent contractors to mandatory vaccinations. And should they refuse to be vaccinated, it is assumed that such refusal would be met with a termination of the employment agreement. This is a misunderstanding of what Regulation 3 stated. In terms of Regulation 3, the employer has a discretion to determine whether he would adopt a mandatory vaccination policy. And should he exercise this discretion, the requirements provide very clear steps to be taken. He must, firstly, undertake a risk assessment, and in so doing, take into account the specific circumstances of the workplace and the requirements of the Occupational Health and Safety Act. He must take into account the operational requirements of the workplace. And he must identify those employees that must be vaccinated because, one, of the risk of transmission through their work, think of the medical profession, or because of their risk to contract severe COVID-19 disease, or because of the risk that they might die as a consequence because of their age or comorbidities. Now, what happens if the employee refuses to be vaccinated on any constitutional or medical ground? Well, the regulation says the employer must counsel the employee, let the employee seek guidance from a health and safety representative or a trade union official, and refer the employee for further medical evaluation when a medical contraindication for vaccination exists. And secondly, the employer must also consider whether the employee can be reasonably accommodated in a position that does not require that employee to be vaccinated, so that, and this is extremely important, the employee may remain in employment. Now, possible measures that the employer could take are allowing the employee to work from home, to work anywhere else off-site, or in an isolated office within the workplace, or even allow the employee to work outside of the ordinary working hours, if that is possible. Now, these regulations are lengthy and complex, and we unfortunately do not have the time to unpack all the requirements. But it is a fact that vaccination at this point is still a choice. It is not yet mandatory. Slide 3, please. The regulations are very strict. It's a fact that people who deliberately expose others to the deadly virus could be charged with attempted murder. And we saw this early in 2020 when a Ladysmith salon owner was arrested and charged with attempted murder after he tested positive and was instructed to self-quarantine, but instead continued to work at his business. And he also attended a religious gathering, thus exposing others to the virus. A similar incident occurred when an Eastern Cape taxi driver continued to transport passengers after he tested positive. He was arrested and charged with murder. I beg your pardon, with attempted murder. It is so serious and so strict that health professionals may lose their licenses. The Health Professions Council of SA regulators said it was investigating complaints against doctors who are proponents of the anti-vax campaign. It is a requirement that all health professionals must advise their patients, and I quote, based on information which is evidence-based and scientifically accurate, end of quote. The regulator said there would be a committee of inquiry, and that committee would determine whether health professionals who are found guilty of having failed to do so, quote, would be allowed to continue practicing, end of quote. Freedom of speech is not a defense. The Constitutional Court held in the matter of the Economic Freedom Fighters and another versus the Minister of Justice and Correctional Services, and this is a 2020 judgment, that, quote, the right to freedom of expression is not an unfettered or an unqualified right. Further, it does not rank higher than other rights in our Bill of Rights, end of quote. Spreaders of fake news relating to COVID-19 are liable for prosecution. Regulation 5 requires people to verify any COVID-19 related information before sharing it with others. If found guilty of spreading such false information with the intention to deceive, the penalty would be a fine or imprisonment for 6 months or both. And in fact, there is a website where you can report fake news, and the website is www.real411.org. Slide 4, please. COVID is officially recognized as a new hazard at the workplace. It is a fact that the employer must protect the health and safety of employees, co-workers, and others who might be put in harm's way at the workplace. A hazard is described as that which shall endanger the health and safety of all concerned. The burning question is this: how can an employer protect the health and safety of employees, co-workers, and others who might be put in harm's way caused by COVID-19 hazard? I want to take you to what Stephen van Niekerk, the head of Momentum Life Insurance, recently said. He said the Momentum Life Insurance data shows that vaccines play a huge role in preventing deaths. Their analysis showed that only 2% of coronavirus-related death claims in July and August 2021 were for fully vaccinated people. Its claims experience until September 2021 suggested, and I quote him, that people who are not vaccinated are 50 times more likely to die from COVID-19 than fully vaccinated people. And that's the end of the Van Niekerk quote. Now, if one looks at the information provided by life insurance companies, it is not surprising that there's an increasing consensus among employers that vaccinations provide a necessary measure to create a safe working environment. Slide 5. The Labour Court requires COVID-19 policies to be strictly enforced. Now, it's a fact that we've only had one Labour Court judgment, and that was in the matter of Escort Limited versus Mogotsi and others, where the court said the following at paragraph 19 of the judgment: the questions that need to be posed despite the applicant having all of these fancy COVID-19 policies, procedures, and protocols in place is whether more than merely dismissing employees for failing to adhere to the basic health and safety protocols, it is sufficient in curbing the spread of the pandemic. Therefore, a policy is not sufficient. The proper implementation is essential. Now, a brief summary of the facts of this particular case, which has been written about quite extensively, is that the employee knew that a fellow employee with whom he traveled regularly in a private vehicle had tested positive. But despite experiencing known symptoms as a consequence, he failed to self-isolate. He was a manager. He ignored being told on no less than 2 occasions to stay home and continued to report for duty, quote, as if everything was normal, unquote. When he finally tested positive, he did not immediately disclose his test results and continued to come to work for about another 2 days. During these 2 days, he hugged a fellow employee and walked around the shop floor without a mask. The court concluded that, 1, the employee was not victimized at any point. This is now through the policy or the consequent disciplinary steps. The evidence showed that the employee was grossly negligent, reckless, and dishonest. That a trust and working relationship between the employer an employee was no longer sustainable, that the dismissal was fair because the employee had breached the regulations which were issued in terms of the Disaster Management Act. It goes without saying that even if the employer does not have a COVID-related policy in place, it may still take disciplinary steps in terms of the DMA regulations, as these are binding on everyone. Slide 6. Could we have the next slide, please? Thank you. Surely my rights to refuse a vaccination are protected by the Constitution. That's a question that we often hear. The fact is that individual rights are outweighed when they impact negatively on the rights of the public at large. Governments worldwide face the same dilemma. Do existing human rights prevent them from compelling their citizens by legislation to be vaccinated? It is a fact that Section 12(2)(b) of the Bill of Rights protects the employee's rights relating to his bodily and psychological integrity, freedom of religion, and freedom of belief and opinion. However, it is also a fact that Section 36 of the Bill of Rights speaks to the limitation of individual rights, when such limitation is firstly reasonable and secondly justifiable. It trumps Section 12(2)(b) of the Bill of Rights in favor of others, and more particularly the public at large in certain circumstances. The principle that individual rights are outweighed in certain circumstances is well established in our law. And I'll briefly pause to take you to 3 judgments. The first is the Minister of Safety and Security and Another versus Kaka. It was handed down in 2002 by the High Court, where the court permitted medical doctors to surgically remove a bullet from the leg of a criminal suspect so that it could be sent for ballistic tests after 2 people were shot dead. The right to bodily integrity was outweighed by the necessity to solve a serious crime. Secondly, the Minister of Health of the province of the Western Cape versus Goliath and others, handed down on 28 July 2008 by the High Court, ordered that people who were diagnosed with, quote, highly infectious, extensively drug-resistant tuberculosis known as XDR-TB, unquote, could be held against their will in isolation in the Brooklyn Chest Hospital until they had sufficiently recovered to return to society. The right to freedom of movement was outweighed by the necessity to prevent the spread of the disease. And finally, in Life Care Group and Another versus JMS and Another 2014 judgment, the court held that doctors could administer a blood transfusion to the minor child of Jehovah's Witness parents who were opposed to blood transfusions for religious reasons. The right to the parents' religious belief was outweighed by the child's right to life. Therefore, if the employer resolves to implement mandatory vaccination, the individual employee's rights not to be vaccinated must be weighed against the rights of others to a safe and healthy workplace. But what if an employee suffers side effects following a vaccination? So far, statistics have shown that about 1 or 2 people per million people may suffer such adverse effects. On 22 October 2021, a notice was published in the Government Gazette stating that the compensation fund will cover employees for injuries, illness, or death as a result of receiving a COVID-19 vaccine, but only, one, where the employer required the employee to be vaccinated as an inherent requirement of the job, or two, where vaccination is required based on the occupational health and safety risk assessment conducted by the employer. And that would have been conducted in terms of Regulation 3. Slide 7, please. In terms of the Protection of Personal Information Act, known as POPI, you can't ask if I've been vaccinated. The fact is, if access depends on a vaccination certificate, POPI will not provide a defense to the failure to produce one. At present, the following applies. Employers can request employees to voluntarily declare their vaccination status. And any information relating to an employee's vaccination status must be gathered and processed in accordance with the POPI Act. Now, what happens if the employee refuses to disclose his vaccination status? There are two schools of thought. The first school says yes, POPI will protect him. The second says it can't. Now, if we turn to the guidelines which were issued by the POPI information regulator, a different picture emerges. Clause 6 of these guidelines specifically deal with issues relating to employment, and it states as follows: that an employer can request specific information and force an employee to undergo testing if that employee's health status might endanger the health of other employees. In terms of Clause 7, an employee cannot refuse consent to be tested for COVID-19 because the regulations, and I quote, require any data subject to undergo mandatory testing in order to manage the spread of COVID-19, unquote. Once the employee has tested positive, he must disclose this fact, quote, to enable the government to take appropriate measures to combat the spread of COVID-19, unquote. It goes without saying that the employer shall also be entitled to demand sight of a vaccination certificate should it become necessary. The issue of vaccination passports is in the news at the moment. In the past 2 or 3 months, there has been a strong push internationally and in South Africa towards proof of vaccinations to provide access not only to the workplace but to other public spaces. It stands to reason that once the requirement relating to a vaccination card or a certificate or a passport to gain access to any workplace or venue gains traction, the issue relating to POPI will be put to bed. It will no longer be a question of choice whether someone will disclose their vaccination status or not. It will be a simple question of choosing to have access by providing proof of vaccination or foregoing such access, or in employment terms, walking away from gainful employment. Slide 8. The new mantra is no jab, no job. Fact is that employers can legally dismiss employees who refuse to be vaccinated. In terms of Regulation 3, employers cannot, however, simply dismiss unvaccinated employees, as I discussed earlier. They have to exhaust every avenue to persuade their employees to be vaccinated. This includes providing extensive counseling and an opportunity to become vaccinated. And if they still refuse, and this is quite an important point, the employer may require the employee to provide a weekly negative COVID-19 test at his or her own cost. It stands to be noted that if the employee does not attend to the workplace for some time because of a refusal to be vaccinated or to provide regular and updated negative COVID-19 test results, the employer could retrench the employee for operational reasons based on a lack of capacity, meaning that employee is no longer capable of providing the services for which he or she was employed. If the employee submits a resignation because of a vaccination requirement, that would not constitute a constructive dismissal. An employee who attempts to refer a discrimination dispute in terms of the Employment Equity Act would also not be successful because the employer would be in a position to argue that the exclusion was rational and justifiable because of its obligations in terms of the Occupational Health and Safety Act, and this is in terms of Section 36 of the Bill of Rights. And that in turn would mean that the discrimination was not unfair. The employee would equally not be able to claim that there was a breach of his constitutional rights in terms of Section 12(2)(b) of the Bill of Rights, given the provisions of Section 36. Slide 9. The requirement of no vaccination, no access. The fact is, excluding access to the workplace, social, shopping, entertainment, and sports venues would then be fair discrimination. To my knowledge, so far some 10 disputes that relate to dismissals and suspensions of employees who refuse to be vaccinated have been referred to the CCMA since mid-August 2021. The referrals have been identified as matters of national interest in terms of the relevant legislation. At present, CCMA and Bargaining Council arbitration awards provide guidance as to how the regulations issued in terms of the DMA find application in the workplace. It is, though, a fact, and colleague Michelle will speak to it, that more and more employers are opting for mandatory vaccination. The burning question is, what if the employer adopts a policy of no jab, no job, and is challenged by its employees? In my view, the challenge by the employees would fail for the following reasons. If the employer had followed the required steps in terms of the directions, Regulation 3, had objectively evaluated the employee's rights in terms of Section 12(2)(b) of the Bill of Rights, or had given effect to the principle of reasonable accommodation where applicable or possible. The challenge would fail because the employees would not be able to show that there was a breach of their constitutional rights or that they were discriminated against. Slide 10. It is your choice as an individual to return somewhat to the old normal or to face increasing isolation. The fact is that billions of vaccines have been given at a global level without reports that there is any association between vaccination and the targeted 23 side effects. Professor Glenda Gray is on record as having said there's been no safety signal, and South Africa is no different to the rest of the world. This means that no evidence has been found that vaccinations are not safe, and no links have been found between vaccinations and the targeted 23 serious side effects, which would include pulmonary embolism, stroke, and thrombosis. Although there is talk that access to public spaces would only be obtained upon the presentation of a vaccination certificate, it would appear that these steps are still in the planning stages. However, should it become a mandatory requirement, it could quite conceivably create a class of citizens who are not allowed to fully participate in many areas of society, such as cultural and religious events, economic, social, and sporting activities. More to the point, persons who are not able to show that they are vaccinated may be denied access to public spaces such as sports grounds, beaches, commercial premises, where, for example, shops, restaurants, gyms, social and sport activities are located. And depending on the employer, an employee might well be excluded from the workplace. Compliance with the requirement to be vaccinated could enable the return to a functional economy and a semblance of the old normal. The facts show that the world is in the grip of COVID-19. It's been described as an invisible but devastating enemy. It has become a fact of life and will be with us for the foreseeable future. Thank you for your attention.
Thank you. Thank you all. I'm going to be dealing with essentially the approach of corporate South Africa and state and educational institutions, and thereafter the global, a comparative global perspective towards mandatory vaccinations for COVID-19. In September 2021, Discovery Health was the first corporate entity to publicly announce its intention to move towards mandatory vaccination requirements for its employees. This is going to be with effect from the 1st of January 2022. And since then, a number of corporates in South Africa have followed suit. And with the fourth wave looming and COVID-19 infection numbers rising, clearly this is one of the most popularly spoken about topics in our present times. It is clear to me after studying a lot of the material that has been made available by Discovery that they certainly applied their minds and carefully considered all the contentious issues surrounding mandatory vaccinations. All the finer details seem to have been contemplated and planned for. The first question that Discovery has answered publicly in material that has been made available through its frequently asked questions briefing to employees prior to announcing the introduction of a mandatory vaccination policy is it informed employees at the outset why it believes it has a right to vaccinate employees. Now, these are the three reasons, essentially, which I've picked out from their brief to be the most profound reasons, or the main reasons they rely upon for implementing a mandatory vaccination policy. Discovery says that in its view, the vaccination or the mandatory vaccination of its employees will be a protective benefit to create a safer workplace. So essentially, what Discovery is saying is we are relying on the science. Pre the vaccine rollout, risk mitigation measures were limited to sanitizing, wearing masks, and social distancing. We all knew the mantra, we all practiced it religiously. And then we had the introduction or the availability of the vaccine. Discovery's view is that the vaccination, or the fact that vaccinations have become available in our country, is going to provide an additional protective benefit. So to supplement that which we've already implemented and which is required by operation of law, and that is the wearing of masks, sanitizing, and social distancing. So that's the first reason that Discovery provided. The second reason is that Discovery says that mandatory vaccinations align with its core purpose to enhance and protect people's lives. So their purpose, their core aims as a business to society and to its employees is also one of the reasons why it believed mandatory vaccinations would be appropriate. And then it also says quite clearly that despite making vaccinations mandatory, Discovery will recognize an employee's right to object, taking into account operational and the business requirements. So essentially, you can see the issues that Hilda just spoke to, particularly when she went through the process with you about how the CCMA and the Labour Court, for example, will evaluate the fairness of an employer's decision to terminate. You would look here on the slide, it almost seems that when Discovery was contemplating this, those very same aspects were taken into account in its decision-making process, because they looked at the health and safety aspects of it, and that would have come from risk assessments, etc. It would have looked at the national objectives and also its core operational and business purposes. And most importantly, it's recognizing that they will take into account special circumstances. They will attempt to reasonably accommodate where they potentially can. Next slide, please. And before, before we go into the approach of essentially going further in terms of the constitutional aspects, it's important to note also from what Hilda had spoken of earlier, that there are more references in the directive which from an interpretation point of view seem to support mandatory vaccinations than references in the health and safety directives which bar it. Because we see the move now, even with the compensation for occupational injuries and diseases, opening the door to claims which relate to vaccinations. Is mandatory vaccination against the national constitution? Now, the way Discovery has answered that question is they've said, look, we've studied it and we're making a call on the constitutionality. We're making a call basically on what we feel is going to be our prospects of success if we are taken on. So what they considered in their decision-making process is that our courts have already made several judicial pronouncements on circumstances under which constitutional rights may be justifiably limited. And my colleague Hilda has taken you some of those cases which have already been decided in our courts, limiting certain constitutional rights. It also took into account that the consolidated direction on occupational health and safety measures actually does make provision for mandatory vaccinations where, say, may be required. There's certainly no bar to mandatory vaccinations in any of our laws, or no express bar, let me put it that way. Instead, what we see is hints in various pieces of legislation mentioning the issue of mandatory vaccination, almost opening the door for that to be considered as a possible risk mitigation measure for workplaces. Next slide, please. Discovery answers the question in relation to employee objections on religious or medical grounds. And their response to that is that they will deal with those objections on a case-by-case basis. They will attempt to reasonably accommodate employees where they can, and they will consider their operational requirements. So what I find is it's going to be very important for employers who are intending to implement mandatory vaccination policies to ensure that they have a very good, solid framework to deal with objections. And as Hilda had mentioned, to provide the relevant education and awareness that employees may require or reach out for, to counsel employees. I think that that's going to go a long way with commissioners and a long way when we are arguing these cases before the labor court, to show and to be able to demonstrate the effort that the employer has put into education and awareness and making reasonable accommodation. Of course, termination of employment, in my view, must be the last resort. What I am not in favor of, and what I've already advised many of my clients, is a heavy-handed approach where you're simply going to go into the workplace one day and implement a rule effective 1 December without consultation. Is not going to be the correct way to go about introducing a mandatory vaccination policy. This should be done with consultation. Even if agreement and consensus cannot be reached, it should be done with consultation, and sufficient time should be given to employees to make the decision and to vaccinate insofar as complying with the policy. Excuse me, 1 second. Next slide, please. What we also saw very recently is that in October 2021, private hospital groups have also followed suit. Mediclinic, they have rolled out the mandatory vaccination policy, and that was very recent as well. The reasons are very, very similar to that of Discovery Health. Next slide. Now, another very interesting development is the fact that BUSA, which is Business Unity South Africa, is also supporting a mandatory vaccination rollout policy for businesses. And essentially, they have based it on the reasons which you see now on your on the slide. They're looking at contributing towards the national vaccination target, which has been set by our government, which is 40 million. We're nowhere close to that target at the moment. They also say that all employees have rights, not only the unvaccinated ones, which I thought was a unique approach, or the way it was put is quite profound, I would think. Also about the legal and moral obligation and leadership roles of organizations. Now, what BUSA is attempting to do is that they want to make an application to court to ask for declaratory relief about mandatory vaccinations. Now, in declaratory relief, essentially what it means is you go to court with a particular set of facts, and you ask the court to make an order allowing you to do something or not allowing someone else to do something. But usually that amounts to asking the court for legal advice, and courts don't like to give legal advice unless there's an actual real dispute. So we'll have to see how far that course of action takes, whether they're even going to launch it, but certainly we've been told that they're taking legal advice on that particular issue right now. Next slide, please. Turning now to state institutions. If we, let's start with the Human Rights Commission, because, you know, there often would be, I would think, the voice that people would listen to in relation to this issue, or would be compelled, will be compelling in this situation. Now, what's interesting about the Human Rights Commission is that they did a flip-flop. Initially, when the issue of possible mandatory vaccinations came out, they said they're against it. In fact, they made a public announcement on television saying that any employee that is going to be subjected to a mandatory vaccination rule at their workplace must approach the Human Rights Commission, and they intend to take it up and deal with the issue. A few weeks later, their position changed. If you do any recent reading of material concerning or from them, you will see that the Human Rights Commission says that mandatory vaccinations can be constitutionally sound, and they, in inverted commas, use the words, again, under the right circumstances. So you can see that they still are maintaining a bit of a cautious, still there's caution exercise, but certainly what they're putting out there is they do not see anything that would be categorically or absolutely unconstitutional and a barrier to implementing mandatory vaccination policies. Next slide, please. A very recent development which actually popped up into my alerts only last night is that the Department of Public Service and Administration has actually published a circular. The circular itself is signed off, when I looked into it, on the 27th of October this year, but it seems to have only made its rounds publicly within the last few days. The department is essentially, in the circular, it explains that it's intending to make vaccinations mandatory for public service workers. And it gives reasons. Again, the reasons I found also very similar to the reasons that Discovery has put out for implementing the mandatory vaccinations. And that is why I spent so much time on the Discovery reasoning, in the beginning, because I'm seeing that flowing through the same trend flowing through many other companies as well as government departments now. The National Education, Health and Allied Workers Union, which is Naidoo, one of the main unions in the public service, has already slammed the circular and has indicated that it will not support mandatory vaccinations for government workers. Naidoo has come out very strong, saying that the department seems to have forgotten that there's a constitution and seems to have forgotten that there's a very intricate collective bargaining structure governing public servants, and that they're going to go hard in opposition to it. So again, it's an issue where we'll have to be watching the space with government employees. Now, what I found very significant, though, is that our courts, our high courts and other courts have actually taken a position in relation to the need to vaccinate. That's amongst themselves as colleagues, as well as parties appearing before judges at court. Very recently, we had an experience in the Durban High Court where a trial had been set down, a 5-day trial, and the judge required all the parties to provide proof of their vaccinations before appearing, and those who did not vaccinate had to provide proof or a clearance in the form of a negative test result. And that is simply directed by the judge. Now, you must understand, in those circumstances, in the jobs that we do, in order to have your time or your airtime in court, which you waited for years, there is a need to comply with these directives from our point of view as lawyers, for example, representing parties in courts where courts have made it clear now, no vaccination, no access, failing which you would have to provide, you would have to convince the court to give you an audience. The only other way to do that is with a negative COVID test results. Now, there is one circular that was published by the Deputy Judge President of Gauteng, which I thought put the concerns that the judiciary is facing on this issue in a way that's quite compelling. The judge said the proper question is whether or not an individual is sufficiently civic-minded to appreciate that a duty of care is owed to colleagues and others with whom contact is made to safeguard them from harm. If one wishes to be an active member of the community, then the incontrovertible, legitimate interests of the community must trump the preferences of the individual. If you are not fully vaccinated, do not enter. So essentially, that is what that DJP's position is. And that message is to parties as well as to his colleagues, include other judges of the same court. Next slide, please. Private schools, Curio School, they have 66,000 learners. They have introduced a mandatory vaccination policy for staff as well as learners. In that situation there at Curio, staff have been instructed to vaccinate before year end or face possible retrenchment. So they have made their position very clear already in terms of what they intend to do. My view is when you're dealing with a situation like mandatory vaccinations, you got your chances or your prospects of success are far better placed in dealing with defending an operational requirements termination over the failure of an employee to vaccinate, rather than dealing with it as a potential misconduct situation or insubordination, which is some ways which employers are considering handling breaches to a mandatory vaccination rule. Next slide, please. In terms of public schools, there's no formal directive that has yet been issued. Department's press releases is that they constantly are taking guidance, and any decision taken will be based on scientific reasons. So they've simply left things in the air. Next slide, please. Universities, UCT has approved in principle to make vaccinations mandatory for staff and students as a condition of attending the campus. So there it is, anybody who intends to be studying at that institution, it's mandatory and no vaccination, no access. For WITS, they have not made it mandatory yet. They have said that they want to rather spend some time on encouraging staff and students to do it voluntarily, and that they will pend their decision. So they don't intend to introduce anything at the beginning of or early next year. Rhodes University has already implemented vaccinations for staff and students. Next slide. Comparative global positions. I always think whenever I'm dealing with an issue where there's a quandary or a debate in South Africa, I always think this debate must have happened in other parts of the world. I did the same thing when I was studying poppy. You have to look at other jurisdictions and see what's happening in those spaces in order to be able to plot how you think that is going to pan out here in South Africa. So let's look at some examples. I want to take you for a little trip around the world now to see what their perspectives are in relation to mandatory vaccinations. Starting from the World Health Organization, they're not in favor of a mandatory blanket approach. Their concerns relate to privacy, rights, human rights, etc. If you go into their website, you'll actually see a very lengthy brief for why they are not in favor of the notion. In Canada, it is mandatory for public servants, for travelers on train, cruise ships, patrons of non-essential businesses such as restaurants and movie theaters. So you can see there which portions, where access. Hilda spoke to a point earlier where she mentioned that it's going to come down to an issue of isolation, an individual's choice to become more and more isolated from society, particularly events or being in public. In the United States, there's plans for businesses with more than 100 employees to require mandatory vaccinations in those environments. In the United Kingdom, it applies, you need vaccination passports for nightclubs. Next slide. France, you need a vaccination passport to enter restaurants and bars. In Greece, nursing home staff, again, common denominator, it seems, bars, cinemas, theaters, wherever there's going to be some form of entertainment. Italy is an interesting case study because they have made it compulsory for all employees. The consequence of non-vaccination is suspension without pay. However, they have also put it out that employees may not be dismissed over this. I think they testing this out as a temporary, or they implemented this as a temporary measure. It could be that the issue of suspension might fall away in due course. And then Hungary, it's for healthcare workers where it's mandatory. Next slide, please. And there you go, more examples on this slide of other countries where mandatory vaccinations have been rolled out partly and not applying to all citizens. Next slide, please. So in conclusion, I just wanted to say it's clear from what I've taken you through that there is significant pressure on government and its departments to make a move now on mandatory vaccinations. A lot of the push is coming from the fact that we're not going to meet the vaccination target, and it appears that pressure is going to be placed on government departments which have significant number of workers, as well as larger corporates, to move towards implementing mandatory vaccinations. Thus far, the resistance to mandatory vaccination policies in corporates has been very low. The reality is that despite the fact that so many big corporates employing significant number of workers have implemented these policies, the noise has not been as loud as we expected it to be. That's the honest truth. So to end, I would just like to conclude by leaving you with these few words, which it's few words, but I think give it some thought if you're contemplating which way to go. Sometimes the hardest thing and the right thing are the same thing. So I thought that encapsulates and some of the guidance that I would like to give to you today. Thank you for attending. And once again, I apologize for the one technical glitch that we had. Hope you enjoyed the presentation.
Thank you very much, Michelle, for that. Thank you again to Dr. Hilda for the presentation. I think just a few nuggets that we did take from Michelle's presentation, that global comparative, and just to see how the rest of the world is doing when it comes to the COVID. I think that's very interesting. And just to see some of the stance that I think the education departments or the education sector has taken. I think that was quite interesting. The universities as well. See, I think Michelle mentioned Curo as one of the schools, and they've taken a strong stance when it comes to the vaccination. I think that's quite interesting to see. I think in the coming months and in the coming months, we'll start to see, I think, a more clearer picture being painted out by the government sector as well. So thank you for that, ladies. Thank you for the presentation. Very, very insightful. Now we've moved to the dessert part of the menu, which is the Q&A. But just before we move to that, I'd like to remind all attendees that you can use the Q&A box that appears just at the bottom of the screen. If you do have any questions, you can direct them to Dr. Hilda, or you can direct them to Michelle. But just before we move over to the Q&A section, there is a small poll that's going to pop up on your screen. If you could just take a few seconds to fill that. It will only take a few seconds, and then we're going to move over to the Q&A. I see that the poll, I think, has really popped up. While you guys are filling that in, I will move straight over to the Q&A. So first question that we have here is from Pearl Kumalo. I think this one is directed at Dr. Grobler. She says, please clarify the retrenchment part. Not sure if you said that there may be an instance where one may be retrenched for capacity reasons regarding vaccination.
Yes, that is exactly what I said, and that would be the last resort. You will recall that I started by saying that all the steps that you have to follow in terms of Regulation 3 is actually aimed at saving employment. So there are three options. The first option is that you be vaccinated. If you decide not to be vaccinated, you must then on a weekly basis present the COVID-19 certificate to show that you are still negative. And finally, if you refuse to be vaccinated or to present the certificate, which incidentally is for your own cost, then the employer has no option but to remove you from the workplace because you are endangering could possibly be a risk to the health and safety of others. And if that is so, and you cannot be accommodated in any of the measures that I suggested, working from home, working off-site, working perhaps after hours, and so on and so forth, if there's nothing that can be done to accommodate you and your position as an individual who has taken a decision and made the choice not to be vaccinated and not to provide that certificate, then the employer is entitled to remove you from or as a member of its staff. At the moment, it's seen in terms of a retrenchment. A retrenchment perhaps is the incorrect word, because the idea is that when you retrench somebody, you can't replace that position. That's the normal understanding. So it goes to the operational requirements of the business. If you cannot provide your services where you won't put anyone at risk, then the employer can remove you because you become incapacitated to provide that service.
Oh, that makes perfect sense. Thank you for that, Dr. Hilda.
You're welcome.
We're going to move on to the next question. I think this one comes from Anonymous and is regarding the POPIA or POPI. So it says, considering POPIA, on what basis are corporates entitled to ask individuals on their vaccination status? What happens if an employer refuses to disclose their vaccination status?
Well, we've dealt with that in terms of what the regulator said. And what the regulator said has been publicly disseminated and is available. And I refer to clauses 6 and 7 of what the regulator had said. And I've seen a lot of comments in the chats, and I agree with the very strong comment in the chat that ultimately we will only have clarity when the Constitutional Court speaks. But until the court speaks, that is the information that we have. And in terms of that information, you do not have a choice. You have to disclose it.
And if I may just add to that, you know, just to pick up from what Hilda said last is, of course, in an ideal, we won't be having this debate if we had the legislature making it very clear that it is not unconstitutional to require vaccinations. You know, the reality is we don't have time to wait for this matter to go all the way to the Constitutional Court. We need to do something now. This morning, I heard on the news is that it's very likely that if we don't reach our vaccination target very soon, that the economic impacts of that is going to be quite severe for us next year for various reasons, absenteeism, another wave, etc., etc. So we are in the situation now where we need to take all this information that we're getting and balance risks. Ultimately, that's what we're doing. We're balancing risks to say, if we take X, Y, and Z into account, would that, are those arguments stronger than A, B, and C, essentially, you know? So that's really what we asked to do as lawyers, balance those risks and would we be able to, well, how high are our risks if we do this? Relating to the issue of POPI, I just want to add two things. Number one, apart from the guideline or the regulation that Hilda referred you to, there's a general provision in POPI which states that medical information or health information is exempted from POPI if it is needed for public health reasons. There's a blanket exemption given. And this is why when we go for our COVID testing, we happily hand over our ID number, our address, all our personal information to whichever service provider it is because POPI is not applying in that situation. For whatever that information is needed to protect public health, that information can be used and not necessarily with consent. The other issue is that one needs to look at the issue of legitimate interests because POPI also deals with that. If there's a legitimate interest for why you are processing someone's information without, you don't need their individual consent. So there's a lot of reasons and a lot of arguments and technical arguments and defenses that can come into it from the person who's using that information or processing that information to be able to defend themselves before the information regulator or in any other body for asking for that information and for storing that information from you. I just wanted to add that on the POPI question.
No, thank you very much, Mish. I think that makes perfect sense. Another question here that came from Gavin is also directed at Dr. Hilda. He says, please could you explain why vaccinated people who may be carriers of COVID-19, sorry, it keeps on moving, who may be carriers of COVID-19 are not required to provide an ongoing evidence of being COVID negative?
That's an interesting one. The fact of the matter is you've been vaccinated, and that means that you have, as matters stand at the moment, ensured that you have maximum protection against the risk. That is one of the reasons also why when you've been vaccinated, that you must still wear a mask and that you must still give effect to social distancing and sanitizing. So it is a contributing factor to ensuring your safety and ensuring that others are not infected. We know because of the mutation of the of the virus. And I'm a layperson when it comes to the medical grounds. I cannot speak for that. I'm not a scientist.
Yeah.
But the fact of the matter is, and we know this and we see this in figures, that it still continues to spread. The fact of the matter is that is the maximum. And you are given a choice in the same way that you are given a choice to give a certificate to show that you've just tested and your test is negative. But there's nothing to say that tomorrow or the next day that you might not contract it. So it's a balancing of, can you provide us convincingly that you've taken all the steps that you are to ensure maximum security or safety from risk? And that's the balance. That's the only answer I can give you.
Mesh, maybe you can tackle this one. This one comes from Anton. It says, can a company be held legally liable when enforcing vaccinations, especially with serious adverse reactions?
Okay, like Hilda said, there is provision now in terms of COIDA that would cover that. So essentially what we must understand about COIDA is that COIDA is an employer's insurance fund. Essentially, it's an insurance from liability. So originally, or the main things that COIDA covers is occupational health, injuries, and diseases. So if you contract an occupational health injury and disease at the workplace, you can't sue your employer civilly for that. Essentially, COIDA, the compensation commissioner, steps into the shoe of the employer, and the claim is then has to be lodged via that office. So it's not a separate civil claim. So in the same way, from what Hilda mentioned about the amendments of the COIDA provisions, it is going to permit claims or injuries or sickness arising due to employees having to take a vaccination, but in circumstances where that is required by the employer. So it actually has to start with the employer then having a mandatory policy, introducing it as we had explained, in order for that to kick in and for the employer to have that cover. Hilda, you agree with that?
I do. And I think, the choice is still ultimately yours. When we say the employer can force you, it's in inverted commas. Say, if you want to work here, then this is what I require. One of these two. This is your choice. You refuse to do either, or you elect to do one of them. And ultimately, the employer, I cannot see how the employer, and I do understand that there might be instances where the employer might be sued, and we'll have to see how that unpacks when the evidence is led. The fact of the matter is, it's your choice. So, as I said, that part of Regulation 3 said that you need to send, if there is a reason why a person says, for medical reasons, I cannot be vaccinated, to obtain further medical information in that case. And then, if that is so, for the employer to try and accommodate you elsewhere in another way for you to work maybe away from the workplace or at different hours or whatever. So there's a whole number of choices that you as an individual can exercise. Yeah. And I think all those issues will be dealt with in evidence. And if you then happen to have the vaccination, as Michelle quite correctly pointed out, and you are one of a very small percentage of people worldwide who react negatively to it, there is a fund to take care of it, to support you. And you're quite correct. It is an insurance fund that is meant to assist in instances now, in the instance of COVID-19 as well.
No, it makes perfect sense. Thank you for that, Dr. Hilda and Michelle. I think looking at some of the questions that are posted in the Q&A, some of them I think would need a scientific opinion. So please feel free to carry on the conversation though, guys. You can carry on using our LinkedIn or Facebook, but all those details we'll post, I think, after the webinar itself. Right now, we have reached the tail end of our discussion. Thank you very much to Dr. Hilda Grobler and Michelle Naidoo for sharing their insights and expertise with us. And I'd like to thank everybody that attended today. I hope you guys took a lot from the ladies' presentations. And I hope that there will be ongoing discussions from here that will help us paint, I think, just a clearer framework of operation in wherever you are working. Yeah, thank you everybody for joining. You can also now view some further information on the screen about solutions in this library, including our Lexis practical guidance and some of our legislation products around the topics of occupational health and safety, compensation for occupational injuries and diseases, and our COVID-19. And as I mentioned earlier, the recording will be made available to everybody, to all our attendees, and you're welcome to share this recording with anybody you think may benefit from watching. Please do stay tuned for coming webinars from LexisNexis, and I hope everybody has a wonderful Tuesday afternoon. And yeah, stay safe and stay well.